Legacy patent frameworks are currently buckling under the pressure of borderless technologies. To maintain oversight, courts and regulatory agencies have begun stretching procedural rules to encompass cases that the original statutes never anticipated. Standard essential patent litigation now operates as a geographical proxy war over jurisdictional supremacy. Simultaneously, the definition of an inventor is fracturing. The rise of AI-assisted generation is forcing patent offices to reconcile modern R&D practices with laws written exclusively for natural human persons. We are going to map the procedural loops driving the European SEP injunction wars, then deconstruct the U.S. Patent and Trademark Office's policy pivot on AI inventorship. These two friction points now dictate the outcome of global IP strategy. In 2026, procedural missteps at the outset often disqualify a claim before its technical merits are ever considered in court. Since the foundational Unwired Planet precedent, the UK High Court has systematically expanded its global rate-setting authority. It treats local patent disputes as an open invitation to mandate worldwide licensing terms. In recent implementer-led cases like Panasonic v. Xiaomi and Samsung v. ZTE, a new judicial tool has emerged, the Interim License Declaration. This mechanism holds the ring. It allows the UK court to set temporary financial terms that neutralize the threat of foreign final injunctions, while a full global FRAND determination is pending. To outpace foreign litigation, the UK is actively accelerating its dockets. FRAND trials are routinely expedited, moving from filing to courtroom within 12 months. Implementers opting for this route face severe retroactive financial risks. In Interdigital v. Lenovo, the court ordered the licensee to pay for all past sales, with interest, explicitly discarding standard limitation periods. By combining rapid timelines with the protective shield of an interim license, the UK has positioned itself as an unavoidable global clearinghouse for SEP implementers seeking safe harbor. That expansion provoked an immediate response. The Unified Patent Court and the German regional courts moved rapidly to protect their own competence to set FRAND outcomes. The German Federal Court of Justice maintains a highly rigid application of the Huawei v. ZTE willingness standard, requiring implementers to prove they are serious about licensing before avoiding an injunction. As demonstrated in VoiceAge v. HMD and Willius v. ASUS, German courts now mandate hefty security deposits from implementers. Without that deposit, the court refuses to even assess whether the SEP holder's offer is FRAND. Look at this injunction logic map. In Amazon v. Interdigital, the Munich and Mannheim courts deployed a novel procedural block, the Anti-Interim License Injunction, or ALI. This order directly prohibits a party from seeking interim relief in the UK. The UK court retaliated against the AILI by granting ex parte anti-suit injunctions, or AASIs, to Amazon and Warner Bros. These orders block the SEP holder from enforcing the German AILIs. A fratal détente was reached when the UK conditionally lifted Nokia's AASI, requiring 21 days' notice before Nokia could file any foreign injunctions related to UK proceedings. The result is a completed feedback loop of procedural deadlock. Current SEP litigation is a tactical race to paralyze an opponent's preferred forum before they can achieve a favorable ruling elsewhere. The collateral damage of these injunction wars has reached the legislative level. The European Parliament is currently suing the European Commission over the withdrawal of the proposed SEP regulation, alleging institutional overreach. While Europe wrestles with structural geography, the United States is fighting a definitional war inside the U.S. Patent and Trademark Office. U.S. patent law is built on a rigid statutory limit. The act of conception requires a natural human person. The Thaler v. Vidal ruling solidified this barrier. It explicitly prevented artificial intelligence systems, like the Dabis machine, from being listed as inventors on a patent. This side-by-side analysis compares the rigid text of the Patent Act against the USPTO's evolving 2025 guidance on AI-assisted inventions. To bridge the gap, the USPTO executed a specific semantic shift, categorizing AI strictly as analogous to laboratory equipment. Framing AI as a sophisticated tool bypasses the Thaler barrier. It places the legal burden of conception back on the human operator. USPTO Director John Squires justified this by stating that excluding AI innovations would jeopardize America's leadership in critical technology. The USPTO is utilizing executive guidance to subvert statutory friction. By reframing the system as a tool, the agency effectively prioritizes maintaining domestic technological leadership over rigid adherence to traditional inventorship. To quantify the human operator's exact contribution, the USPTO relies on the PANU factors. These legal tests determine whether a human's interaction with an AI system was significant enough to qualify for inventorship. In Ex parte Desjardins, USPTO Director Squires led the Appeals Review Panel to overturn a Patent Trial and Appeal Board rejection of AI-assisted claims. The panel validated the patentability of known machine learning functions because the human operator met the PANU factors during the actual deployment of the system. Meanwhile, the PTAB is tightening validity standards elsewhere. In Recentive Analytics, they used Section 101 to reject generic machine learning models as unpatentable abstract ideas. Rulings in Ecofactor, rulings in Duke, and in CGen have consistently overturned multi-million-dollar jury verdicts due to flawed damages models or insufficient written descriptions. Outside the United States, the approach to AI inventorship diverges sharply. The European Patent Office and the UK Intellectual Property Office reject the American workaround, maintaining strict adherence to the legal person requirement for inventors. In China, the National Intellectual Property Administration implemented Order No. 84. This mandates detailed technical disclosures of AI models, training processes, and data relationships before patentability is considered. Securing AI inventorship is now a highly fragmented compliance issue. Companies must execute entirely distinct prosecution strategies based on the specific regulatory framework of their target jurisdiction. Looking at this matrix of jurisdictional risk versus inventorship complexity, the data is clear. Technology has outpaced legacy IP frameworks on both the structural and definitional axes. For SEP litigation, the directive is sequencing. Litigators must engineer their multi-jurisdictional injunction strategy long before filing a single substantive infringement claim. If you utilize the UK interim license mechanism, you must preemptively anticipate an anti-interim license injunction from the continent and prepare immediate countermeasures. For patent prosecution, U.S. practitioners must rigorously document human contributions under the PANU factors during the R&D phase. This is the only way to shield AI-assisted patents from future PTAB invalidation. You must also account for the heightened risk of Section 101 challenges when relying on generic algorithms that lack specific, measurable technical improvements. Success in this environment requires calibrated execution across multiple actively hostile legal regimes. In the absence of global legislative consensus, effective IP practice in 2026 relies entirely on finding and exploiting the procedural loopholes between competing courts and shifting agency directives.